Good morning, Talking Law with Eugenia. I'm your host, Eugenia Matthews, and I have my special guest again, Mr. Henry James from Henry James Legal. His phone number is 0414 414 520. We're going to talk to you today about intervention orders because that's the request I've had. A bit of traffic law, some criminal, and if we get some questions, because I was told by a listener that she forgot to listen last week, but she would text through some employment industrial law. So if we get some questions, I'll talk about that as well. So today we're going to discuss an intervention order. What is it? If you're the victim, what does that mean for you? How does it work? If you're the accused, what happens? And what happens to the intervention orders when usually you get a charge of aggravated assault laid because the allegation is you've assaulted your partner? And what happens if it's breached? What happens if there are family law proceedings because this has separated your relationship? That's what we're going to talk about today. Now, if you get your pens ready, if you want to text while we're on the show, it's 0401 269 091. That's 0401 269 091. And the program is brought to you by Adelaide Hills Toyota. Welcome, Henry.
Hello, Eugenia.
Okie dokie. You'll notice I've trained him to just say hello at this point because, as you know, we always go to a song. That's where we're going to go. We'll check our phones and see what messages have come through, and then we'll get straight into our discussion. Enjoy this one. It's Maggie May by Rod Stewart. And I am back. Eugenia Matthews, Talking Law with Eugenia. Program is brought to you by Adelaide Hills Toyota, and I have Henry James with me on the program today from Henry James Legal. We'll do a proper introduction this time. How are you, Henry? What's going on?
I'm well, Eugenia. I'm keeping very well, thank you, despite the cold weather.
Cold weather? Oh, as you know, I was as sick as a dog last night. People, if you're lactose intolerant, take your Lactase before you have anything with lactose because it wasn't too good last night. But we had to come and do the show because it's important. You ask and we try not to let you down. Domestic violence and intervention orders. I know it's a bit silly because you all know this, but we're going to talk about what it is because, believe it or not, I had a young lady in my office this week, and Henry will, I'm sure, confirm this, and she didn't even know that she was being abused. He was raping her while she was asleep and inserting things. If this is going to cause you problems, everyone, there's Lifeline 131114 or 1800-RESPECT. Go to your community health centre or your doctor. Go somewhere, talk to someone. It's not going to be a pleasant discussion. But that young lady had to be told that what was happening was actually an assault. Yeah. So just because everyone says, oh, yeah, but you're going to bore us with what domestic violence is, we know what it is. Well, clearly, not everyone does. So what it is when someone close to you threatens you or does something to harm you or someone else in your family. It can include, it can be physical, punching, hitting, kicking, pushing, slapping, choking, or using weapons. Sexual assault, as I've said, you could be forced to do things either by watching or participating, or you could wake up to being sexually assaulted. He might or she might treat you badly, making you feel like you're nothing, worthless, criticising how you look, the way you dress, putting you down, following you. There might be economic abuse. That's where they withhold their wages or money so that you can't actually buy clothes, buy food, or as much as what you need. You can't pay the bills because he's controlling the money and you have to keep begging for money to buy even a litre of milk or some bread or to pay the electricity. Could be threatening or intimidating, such as stalking you, yelling, name-calling, swearing at you. Could be damaging your property or even threatening to damage your pets. And any other controlling behaviour. If you feel that your life is not your own, because you always have to worry about what your other half thinks, then you are in a domestic violence relationship. And this can even include overhearing threats of physical abuse by one person to another in the family. That would be your children. Don't think that just because it's not done in front of the children, they might be in another room, that they're not hearing it, or they might see it. Even if the police come or the ambulance comes and they're dealing with the aftermath of you being abused, they're witnessing domestic violence. It is unacceptable. If this is happening to you, report it. Tell someone. You do not have to be unsafe. So that's what I think you should do. I think anyone in their right mind, when you go to them and you tell them what is happening in your life, nobody's going to laugh at you. No one's going to think you're stupid. And if they do, they're not worth you hanging around with anyway. Have I missed anything, Henry?
No, not at all, Eugenia. And I think it's interesting that we spoke about at quite a lot of length last week about bullying and harassment in the workplace and the psychological mind games that people play on each other. And certainly this is similar, but in many regards is worse because it's within the four walls of the private home. Certainly the impacts on people that are affected by it are diabolical. And I think Eugenia is right when she says half the battle is victims trying to identify that they are victims and that people will believe them, that people do care about them. And knowing that you're not alone in these situations is so important.
Absolutely. So, people, what you do if you find yourself in a situation where you don't feel comfortable or you can't do what you would normally do, what you used to do before you were with this person, then you are in a relationship that is not positive. You can get out. It might take you 2 or 3. We know the statistics tell us it's about 7 times before you escape. It doesn't matter how long it takes. You do it at your own pace. Nobody can judge you. They haven't walked in your shoes. And throughout the process, especially with the parents, you're always thinking, but if I split the family up, my child won't have a mum or a dad or whatever. A child that is happy is a child that will be well adjusted even if you have separated. Obviously, we want families to stay intact. It's not always possible. And believe me, if your child is witnessing abuse, they're not happy. And it will affect them as they age. So, we're going to go to victims now. And Henry is going to take you through some of that discussion while I check the phone because someone texted. Up to you, Henry.
So I suppose the big burning question for anyone who's a victim is what can they do about being in a domestic violence situation? Well, my advice to people is the first thing you should do is go to the police and report the incidents to the police, because in the first instance, if police believe that there's enough grounds to do something about it, they can commence an intervention order on your behalf. The benefit of that is that you have all the resources of the prosecution branch behind you as the victim. It won't come at any personal cost to you. The police will effectively run the matter in the courts on your behalf, and in many cases you won't even be required to attend court, at least in the early stages of that application. If police don't think there's enough evidence to justify pursuing an intervention order on your behalf, but you, notwithstanding, feel as though you very much genuinely are the victim of domestic violence, and importantly, without an intervention order, feel as though you're at imminent danger of harm, you can also contact a private solicitor and place what's known as a private intervention order. The problem with that, however, being that does come at your own personal expense. Now, there are lawyers around that will possibly be able to talk to you about fees in certain circumstances, particularly if you're a financially disadvantaged person. But my point being, whether police take it up or whether you have to go about it yourself, no one should suffer in silence. If you feel as though the intervention order is necessary, then you should pursue it, because the whole point of an intervention order is to try and protect people in situations where if nothing was done, who knows what might happen to them. And I without meaning to sound grim, that who knows what can happen could in some cases be fatal.
Absolutely can be fatal. And for you to get an intervention order, as Henry told you, with the police it's free. If police won't help you, you can get your own intervention order. You'll be making a private application. Take some notes, make a list of the things that have happened where you have felt unsafe. Try to include details of when and where those things happened, and if there were any witnesses, who are they? Your statement when you make it to police, and your notes will help, will be your relationship with the person who you're saying is abusing you. If you have children, their names and their ages. If they've witnessed it, say that. Are there any drug, alcohol or mental health issues? Does he or she have access to a gun? Talk about the actual acts of violence, whether they're physical threats, intimidation, stalking, sexual property, or even dangerous driving. You could be in the car and he's driving like a lunatic, and you're worried that you're going to run off the road. If there are any harassing phone calls or texts or emails, write all of these down, because you've got to come within Section 8 of the Intervention Orders Act. So that's why you having all of these things ready at your fingertips will help you when you go to the police so that they can help you.
I mean, that all comes back to what Eugenia and I have mentioned many times in this program before. The law is quite hard in the sense that all the courts really care about at the end of the day are the facts. What can the parties prove? So your evidence is so important. The court won't just take your word for it on its own. You need to have proper evidence, so that, as Eugenia says, that proper diligent record keeping is so important. If you feel like you're being abused at home, make detailed notes, keep a diary of some sort, whether that's on a hidden part of your phone because you're worried that your partner might find it. You may have to be discreet about how you keep records. You may have to be a bit underhanded and sneaky about how you do it. But at the end of the day, when you finally decide to break free and go to the police and beg for this application, the first thing the police are going to want to see is the first thing the courts are going to want to see, which are basically the evidence that backs up what you're saying.
And the evidence might be your statement originally. Whether it's true or not from a defence perspective is another issue altogether. But that would be enough in most cases to at least get you the interim intervention order, because at your first hearing, the accused isn't there. So the court will hear from you or the police, if you're not there, about why you should have an order to protect yourself and or your children if necessary. There could be clauses about staying 100 metres away from where you work, live or go. Could be that they can't, if the children are on there, that they can't go near the school. There are a whole number of things that could be on the intervention order, but you can't get one unless you have evidence. And if possible, if you have talked to a professional, whether it's a social worker, psychologist or a medical practitioner, that's going to help you, because you will have objective evidence about what happened. Because he's going to say, and I'm only using this in the sense that we know statistically that it's mainly men abusing women, but I can tell you I've seen it the other way too. So it's important that you get this right, because he's going to say if it's... well, that's what she says. That's not what happened.
Well, I'd actually chime in at this point, Eugenia, and say that more and more these days, I think men are actually finding their voice when it comes to facing up to the fact that there are abusive women out there.
That's right.
That cause men as much drama as the men have traditionally caused women in domestic situations.
And it's not politically correct for us to say that, but that actually is what's happening in the courts. And I don't care whether you're a male or a female or however you identify. If you are being abused, you don't have to be abused. If you are the abuser, we're also going to talk to you and tell you what you can do to change your behaviour, because you really don't want, do you, to have a relationship with someone who's only there because she's scared of you.
And I think a message I really want to get out there is the blokes out there shouldn't feel that it's unmanly to stand up for yourself. It's not unmanly to stand up for your children. It's not unmanly to face up to the reality that you might be suffering from an abusive partner.
That's right. And the old days where... I can't believe this actually happened 5 years ago. You'll never believe this. No one believes me when I tell them. But I had a male client who went to police, and police said, well, why didn't you just lay back and enjoy it? And of course I rang and had quite a lot to say about that kind of behaviour. It's changing, but you should still go. And if police won't help you, find your lawyer. Get your own lawyer. There are community legal centres. There's the Legal Services Commission if you need free advice. For women, if you can't afford your own lawyer, there's the Women's Domestic Violence Court Assistance Program and the Women's Legal Service. There are places you can go. If you are deemed to not meet their merits assets test, then you'll have to pay for it yourself. But being prepared and having your evidence, dates, times, who was there, what happened, how did you feel, and getting some professional help will assist you greatly in getting an intervention order if you are a victim. Now we're going to go to a song, and when we come back, and this time we're going to play Maggie May, when we come back we're going to go on a little bit more, and we're going to talk about the intervention orders, what happens if it's ignored? Can he or she find my address? How long does it last? And can you enforce it Australia-wide? And then we'll get on to the abuser, because we want to be fair. And if the abusers are listening, you don't have to be embarrassed. If you go and get help, trust me, you're going to be treated with the utmost respect, because asking for help is a very important thing. The program's brought to you by Adelaide Hills Toyota. Talking Law with Eugenia, I'm your host Eugenia Matthews. The program is brought to you by Adelaide Hills Toyota, and my special guest is Henry James from Henry James Legal, 0414 414 520. I don't have to look that number up anymore.
That's a good number, that one.
Now, we did get a question from someone who says, if I go to police and make a complaint, do I have to go to court? Which is funny because it's one of my questions already. Look, if you make the application yourself, you have to go because it's your private application. You are the plaintiff bringing the case against the other side, so yes, you do have to go. If you are represented by police because police have decided they think there's enough for them to help you, you may not have to go. I always think that you should go. At that first hearing, your other person, the one you're complaining about, is unlikely to be there in any event, so you'll get an interim intervention order. It'll be adjourned to another date and he'll have to come and answer at that point.
I often find that for clients in any type of matter, you're far better off attending the courtroom, being there and seeing everything in the flesh, rather than sitting at home and sweating bullets wondering about what's going on elsewhere. I find clients are actually more stressed if they don't turn up to court and they sit at home and worry about what's going on, rather than ones that are actually actively participating in the process. And what I'll say about requirements to attend, if you're the defendant on any application, you must attend.
Absolutely.
And if you fail to attend, not only will the court most likely in some cases find very much against you, and you basically you rob yourself of the opportunity of any reply. But also, it's technically a contempt of court issue where they can issue certain applications known as a warrant for arrest, which is where the police will basically go on a bit of a search parade to look for you, and the minute they find you, they go and lock you up in the cells. And certainly the worst time for that to happen is either Friday night or on the weekend, because you have to basically stay in the cells until the following Monday afternoon, when a magistrate can finally hear your matter, and you can explain to the magistrate why it is that you didn't feel it was important enough to turn up to court that day, and then hope and pray that they then release you. You can avoid all of that drama simply by turning up.
Exactly. Now, if your intervention order, one thing is, do I have to leave my home, was one of the questions. The defendant may be ordered to stay away from the premises, even if they own them or even if they rent them. If you're in rented premises, he will have to move, and the defendant might want to go to the SACAT, South Australian Civil and Administrative Tribunal, to either ask to remain in the premises as a sole tenant or to terminate the tenancy. But that's unlikely to happen, because in these matters there are strict rules about what happens to a victim, and at this point you're a victim. It may be possible, but it's unlikely, so if you are the defendant, you will most likely have to leave the premises. It might be that you can still talk to each other, but usually there's a clause that says parties are not to communicate directly or indirectly except as otherwise permitted by the Family Law Act.
And that leads into something that's really important that I've observed in practice, is particularly where there's a romantic relationship involved between the applicant and the respondent or the defendant. There's often the temptation that arises where one partner says to the other, I've forgiven you, you can come back into the home.
That was one of our questions.
That's all well and good, but if the court hasn't deemed that the intervention order should be revoked, either the interim or the final intervention order should be revoked, then technically you're in breach of the law. And what can happen there is this partner who's brought you back into the home, it could turn out that it's a bit of what they call colloquially a honey trap. Exactly. Where they've gone, oh yeah, come back into the room, darling, and you know it'll all be sweet, and next minute you know they've called the police on you, and you've got 3 or 4 policemen crowded around you, demanding to know what the hell you're doing, bothering the protected person, and off to court and off to jail you go.
And they are prohibited from being released on bail because they come under Section 10A of the Bail Act. So it might take a couple of weeks to get you out. If the court has made the interim intervention order, so the police will get the paperwork ready, they'll go to the court will make an interim order. That is an order. The alleged victim cannot tell you that you can go over, because the court has said no, and if you go, you are at risk of being arrested. I have seen that happen. Don't do it, because if you do, you are going to be in custody. You will be charged with breach intervention order. There are penalties, and they include imprisonment, and I'll talk to you about that later.
Well, one of the most common ways that I've seen it happen in practice is where, for example, you've got girlfriend and boyfriend, and the girlfriend says to the boyfriend, I want you to come round to the house now and collect all your rubbish. I've left it all out on the street. It's about to rain, so if you don't want your Xbox damaged, you best come round and pick it up now, buddy. And then they come around to pick the items up, and then that often gives rise to the ability for the girlfriend to then maliciously call the police and say, he's come to my house, he's bothering me, he's banging on the door, he's banging on the window, I feel scared. And the police get round there sharpish, and lo and behold, they see you on her front lawn. They think they've put 2 and 2 together, and before you know it, you're getting wheeled before a magistrate to explain yourself.
And if there is a distance clause telling you that you cannot go within 50 or 100 metres, you're definitely in breach. Look, did you know, Henry, under the new penalties, a breach of an intervention order under Section 31 is 3 years for a basic offence, an aggravated offence, that's where the child was reasonably likely to have seen or heard it, is 5 years. If you breach your intervention order again, it's 7 years imprisonment. And any more than that, it's up to 10 years. These are serious penalties. So if you don't want to risk jail, which I recommend you don't, or you want to take your chance, then you take the chance that that's going to be your penalty.
But you need to be very, very aware that it's so possible to get caught out on a technicality. It is folly to think that the only way you can breach the intervention order is by being violent towards your former partner or whoever it is that's put the intervention order out against you.
That's right.
It is not just a case of whether you are actually violent towards them. It is simply a case of, have you breached any of the conditions of the intervention order? Because the way the courts perceive it, there is no reasonable excuse for basically defying what the court has told you to do.
Exactly. And there's always a clause not to publish on the internet or by any other electronic means. So if you put a photo up of you two last Christmas, you're in breach of the intervention order. So,
well, arguably, even if you text them, and even if it's the most
communicating,
even if it's the most benign thing, and that can be very difficult where you've got two people that are the parents of a child, where one parent may purport to message the other parent to say, little Timmy's had an allergic reaction to his breakfast cereal. What do I do? What do I do?
It's a breach.
It's technically a breach to respond to that.
That's right. Okay, we're going to talk now about you, the person who is accused of all of these acts of domestic violence. When you receive the intervention order, regardless of the fact that it's not actually a criminal matter, even though it's heard in criminal court and won't become part of a criminal record, the fact is, as we said over and over again this morning, if you breach it, you're going to be in trouble. So, don't do that. We've told you what an intervention order is. It's when you commit an act of that causes the other person either injury or where they're scared. If that happens or your children witness it and they're frightened, it's an act of abuse, and the intervention order, which is the new word for the old restraining orders, which is to stop you from committing acts of abuse, you're going to get one of those. Now, when can an order be made against you? Well, it can be made at any time that someone complains about your conduct towards them and goes to the police and tells them what you're doing or what they say you're doing, and they can produce some evidence. The police will take that information. They might think there's enough and file an application and bring it before the court. If police can't assist you, then you'll have to consider getting your own intervention order. So, what happens when you're questioned by the police? Henry, this one's yours.
What happens is you keep your mouth shut.
Exactly.
What I say to people all the time is you have certain requirements of things you have to answer, but that is strictly limited to what is your name, what is your address. Then if there's certain questions about whether a particular motor vehicle was being operated by yourself at a certain time and date, you have a requirement under legislation to answer that question. You also have the requirement to answer the question about whether or not a particular firearm was in your possession or belongs to you.
Exactly.
Beyond those four questions, so your name, your address, details of a motor vehicle, details of your ownership of a gun, you keep your mouth shut. I cannot stress that enough. There is a real tendency, particularly in young blokes, to think that they can explain their way out of something, that, if the cops just hear what I have to say, they'll see things my way and it'll all be sweet and it'll all go away. Absolute rubbish to think that. There is, as a senior barrister has once said to me, there is nothing that can be explained to the police on the spot that can't come from the solicitor's letter on the Monday after. There is nothing that you can say to the police that your lawyer can't say for you in writing when you've had the proper chance to sit down, take a deep breath, have a proper think about what you want to say to the police. Trying to talk your way out of it does you no favours whatsoever.
Absolutely not. And the other thing that I want you to do is have a PIN number on your phone. It's the case of Midland and Hannah. It's a reasonably new judgment for us, but that's basically the new judgment that says what the Americans have called the right to not incriminate yourself. You don't give police the PIN number to your phone, and if you have a laptop, you don't give it, because they're going to go through that, and they're going to, because you're a suspect, what they're doing is they're trying to gather evidence against you. Do not give your PIN number, and do not have just a 4-digit PIN number. Have a 6-digit, or if you can, have biometrics or whatever. Don't give your PIN number to your phone.
It might sound a bit strange, Eugenia, coming from an experienced criminal defence lawyer, but by and large, I have an enormous amount of respect for most police officers, and I think the police have an impossibly difficult job to do day in and day out. But having said that, they are also, by and large, very well trained at getting the absolute worst out of people when it comes to interviewing and talking to people. So whilst you might think you can outsmart the police, you may find it's very, very alarming to find just how easy it is for them to twist what it is that you say.
And I'm going to give you an example of that. She will allege, as I said, I'm just being stereotypical here, that you've pushed her or shoved her and she fell backwards. You want to tell police, well, I did push her back because she was coming at me and I was fearing for my safety. So you've admitted that you've shoved her, that's an assault, and they might say you used excessive force. So with the intervention order later, you're going to be charged with an aggravated assault offence.
Well, you've left the door wide open to a number of allegations at that point.
So you need to know that exercising your right to silence, because some people say, but I was always told to tell the truth. Exercising your right to silence isn't lying. It's your right.
It's to be perfectly blunt. It's saving your tail.
Exactly.
Eugenia would probably agree with me that the first thing that we do when any criminal defendant comes to us and says, I need help from a lawyer, I didn't do this, how can you get me out of this? The first thing that I do is look through the file, look through all the evidence that has been provided by the police and see if any admissions were made at the point of arrest. If you've come out of the blocks and admitted to doing the offence right at the beginning when the police have first spoken to you, that can often limit your options enormously for what we can then do for you later in court.
Exactly. So we're not trying to stop you from taking responsibility, and certainly if clients come to me and say, look, I did actually hit her, I lost my temper, or I just snapped, those clients are usually so frightened. They're not the ones we're worried about, because they're the people who aren't going to assault again. They're so scared they'll go to their doctor or they'll get on a program, and usually those relationships last. It's the ones who don't accept what they've done and try to minimise it. They're the ones that we're all scared about, and so are police, and rightly so.
And look, I think everyone wants the truth to come out. The truth can come out even if it comes out later in court. It doesn't have to be argued and fought there and then when the police first come to speak to you.
Exactly.
You wait your moment, you pick your moment, you keep stum when the police first speak to you, you then get proper competent advice from a lawyer that you trust. That's a common theme in a lot of our discussions, Eugenia. Yeah. It doesn't have to be Eugenia, it doesn't have to be myself. It has to be someone that you trust to deal with your matter properly. Once you've gone and received that competent advice, you then, at the direction of your lawyer, find an approach that allows you to negotiate the matter sensibly in a methodical and well thought out way. There is no sense trying to make it all go away on the spot with the police officer in the heat of the moment.
No, because all you're doing is opening yourself up to extra charges. Now, when you do appear in court, if you are the person accused, there are other orders that the court can make, and they might send you to be assessed for and undertake an intervention program, an abuse prevention program that the court runs. And if you've been ordered to do that, you must actually do it. If you don't, you will be in breach of the orders of the court. Contempt of court proceedings might actually come at you because you're breaching an order of the court.
And at that point, when it comes to trying to beg the magistrate for a favourable outcome, you are well far behind the 8 ball.
Exactly, and it's a breach of Section 31, subsection 1 of the Intervention Orders Prevention of Abuse Act 2009, South Australia. There is a fine. The maximum penalty there is $2,000 or imprisonment for 2 years. The courts, as society does, takes a very dim view on these types of things. So don't think that you can sweet talk your way out of it. You can't. You will be in trouble. So if you breach it, don't do it.
And the problem there, Eugenia, the reason I think why, by and large, these offences carry quite significant penalties is that from the court's perspective and from the perspective of the government, once the court's imposed an order that lets you remain in the community by and large but just places some restrictions on certain behaviours, if that has been attempted by the courts and it hasn't worked, as in despite the serious application for an intervention order being imposed, if that hasn't been enough of a deterrent, the court has to say to itself, how much more do we have to do to keep the protected person safe? How much more do we have to do to stop this person from behaving these ways? Unfortunately, at that point, the court may often decide that for the safety of the community, there is no other further thing it can do than to put you back in jail.
Exactly, and that question was the question from a listener. Should I go to the court counselling program? Yes, if it's been ordered, even if you haven't done anything wrong. You don't have to admit the offending at that course, and I certainly would not recommend that you discuss your charges and the facts that support the charges at that course, but you will learn some skills, and that's actually important. We're going to go to a song. We haven't had time really to talk to you about traffic law, DUI and PCA, but look, if you've been charged by police with a driving under the influence or a prescribed concentration of alcohol, what you should know is that they can't run both charges. So your lawyer will be able to say to police, you have to elect which one that you want to run with. I certainly will not allow police to run both charges, and the court won't either. But if you represent yourself, these are the sorts of things you don't know because you haven't done a law degree. We're going to go to a song, and then we're going to finish off Talking Law with Eugenia. I'm your host, Eugenia Matthews. My special guest is Henry James of Henry James Legal, 0414 414 520. And we're going to Smokey this time. So I hope you enjoy that song, and when we come back, we'll finish off. Okay, I'm back. It's Eugenia Matthews, because we're going to run out of time. There are a few things we want to tell you. When we say that you should get legal advice, it's important. Henry made a good comment while the song was playing. What do we lawyers do when we have to answer questions?
Well, I've always said to people that the person who represents themselves has a fall for a client. And I find it's interesting that even us lawyers, on the rare chance that we get into mischief, either in the civil or sometimes the criminal jurisdictions, and certainly I've never been in trouble that way, but others have, perhaps
it's been on the news.
Drink driving, or drink driving is probably the common one in our profession. what we find as lawyers is we often get another lawyer to represent us.
Exactly.
So if the lawyers themselves aren't representing themselves, the average punter on the street should never represent themselves.
Exactly. Okay, so even if the protected person wants to contact you, you must not disobey the intervention order before it has been changed. Serious penalties, which we've talked to you about, even though